and this is a victory for all of us.
Clearly, the eloquent words of Prime Minister Trudeau do not reconcile with his actions on the ground.
Consultation as it is not good enough if they're going to live up to the commitments that they've made to Canadians.
Obviously, this is devastating news for energy workers across Canada.
We know that this pipeline, which is in the national interest, needs to get built.
Court of Appeals ruling has halted construction of the Trans Mountain expansion project indefinitely. That leaves Ottawa potentially facing additional years of regulatory reviews and consultations with Indigenous groups. It's a political headache for Prime Minister Justin Trudeau and Alberta Premier Rachel Notley, both of whom are facing re-election. So tonight we're going to ask our panel what will be the political and the economic consequences of this court ruling. Joining us from Winnipeg via Skype is Pam Palmater. She is the Ryerson Chair in Indigenous Governance. From Toronto, we have Tasha Kheiriddin, host of the Tasha Kheiriddin radio show. And in Ottawa, Globe and Mail columnist John Ibbitson. Thank you all for joining me tonight. Pam, I do want to start with you because we've been talking a great deal about First Nations communities celebrating, claiming this as a major victory. How major a victory do you see this as?
Well, it's a significant victory because what we're talking about is constitutional law. And every time a court in this country upholds the constitutional principles, that's good for everybody. It's good for Indigenous peoples, it's good for Canadians, and it's good for investors. There's no worse place to invest than a country that doesn't abide by its own constitution or its own laws. And this is a court case that's very significant because the law in this country is not just consultation. That's the word everyone uses, but it's consultation, accommodation, and in many cases, consent. And that's the law in this country. And so the fact that they upheld that is a significant victory for Indigenous peoples and all Canadians.
John, a significant ruling, a surprising one too. I mean, you followed this, as have I, and many others, all of the consultation that took place here. Were you surprised to read this ruling that this was not adequate or meaningful consultation to engage with First Nations given the steps that were taken?
Well, given that lower courts were satisfied with the level of consultation, yeah, it was a surprise that at this final appellate level, they decided to override previous decisions. I mean, it did come as a shock. And it raises fundamental questions. I don't interpret the Constitution the way Pam interprets it. I don't believe that our governments have been violating the Canada Act for decade after decade. But the Supreme Court and other courts are moving towards an interpretation of the Constitution that seems to suggest that consultation almost implies approval. What does approval mean when there are more than 600 First Nations across the country? What is it, a majority approval? And what happens if you don't have that approval? This is a real world situation. It's not something that's fought in courtrooms. There are thousands and thousands of energy sector jobs at risk right now because of this court's decision. And indeed, if on all natural resource development across the country, whether it's mineral or forestry or natural resources, oil, we have to have an absolute consent on the part of Indigenous Canadians before anything can proceed, then what is left of the Canadian economy? I mean, what do we do for a living? What do we make here? What do we sell? How do we pay for our hospitals and our bridges and our schools and our social programs? I think we are moving towards a really existential question. How do we keep the place going if the courts are going to interpret the duty to consult the way they seem to have interpreted it here?
Tasha, I know you want to weigh in on this, so go for it.
Well, I take John's point on that, and I do also disagree with Pam in the sense that consultation implies consent. That hasn't been the standard so far. I do wonder if the court might have also taken into consideration the backdrop of the government, because this is a government that has essentially held itself out as, very much in favor of reconciliation, improving relations and the living conditions and other things of First Nations in Canada. And I'm wondering if they, in fact, setting the bar as high as Trudeau did in the last campaign and since he's been elected, in a sense, might have inspired the court to say, you know what, you haven't met the sort of level of importance on this file that you said you would give to it, i.e. you haven't consulted enough as we would expected you to do. Is that the subtext here? I think if that's the case, then one can look at the government and say this is a major failure on their part, essentially, to get this process through. I do agree, though, that consultation does not imply consent, and the result of this situation now is that the government could go and appeal this. Would the Supreme Court overrule this and go back to a lesser interpretation of this? That's a big gamble. So right now, if I'm an investor looking at Canada, this has huge implications because, as John said, it implies that there's a lot of unknowns now. The federal government's word is not its bond.
Pam, there's talk about the many options that are now before the federal government here as to what to do, and one of them is to go back and consult with First Nations. That was not done to the extent that the court required the first time around. So what do you think it would take in order to, what would adequate, meaningful consultation actually look like?
And see, you've just hit the nail on the head with the whole problem. This isn't about just consultation. The Chilcotin case was very clear that in cases where there's Aboriginal title and assertions to Aboriginal title, we're talking about exclusive ownership. That means the right to say no. And the court did in fact say that means consultation, accommodate what you heard from those people, change your plan, take mitigative steps on any potential damages. And in some cases, it will in fact require consent. And consent was mentioned many times over in that Chilcotin case. So the fact that the government just focused on talking to people, giving certain amount of information to people, hearing what they had to say, but not taking any mitigation steps or considering that in some areas you might need consent because of Aboriginal title, that's where they fell down. When you only focus on consultation, you're missing the whole purpose of Section 35.
But there was some consent. Some Aboriginal groups, some First Nations did consent. And this is the issue, though. But this is the standard the court is setting up essentially sets up a double standard in Canada, because there are situations where the federal government expropriates with compensation. Governments of all level can do that. It's almost taking that off the table here. If you don't get consent and you oppose the development, for example, pipeline, I agree, compensation could be a way to deal with this. That wasn't mentioned here. That whole piece is gone. So essentially it is holding the government hostage to a decision without any other options.
That's such alarmist language. We're talking about Section 35 of the Constitution. And when we're talking about Aboriginal title areas, so some First Nations may consent in their territories, but in those with Aboriginal title who said no, it's their land. It's not the federal or provincial governments to expropriate. It is Indigenous land. And it's not something that we can say, well, we agree with all the other constitutional rights and charter rights, and we protect those, and there's no legislation to get around those. However, when it comes to Aboriginal rights, we're only going to do it if it's convenient to us or if it meets with oil companies' shareholders. That is the double standard, not the protection of Section 35.
John, what's the politically smart move here for Justin Trudeau, a prime minister who has spoken since the day one of his election about reconciliation and working with First Nations communities, and this is not a good day for him?
There is no politically smart move. This is just a huge defeat, plain and simple. There's no way around that. And considering the problems with the carbon tax, provincial opposition to that, the problems with refugee claimants crossing the border in Quebec and Manitoba, and of course the fraught what is going to happen over the next 24 hours dilemma with North American Free Trade Agreement, it's a pretty bad week for the government. But I don't think we should just focus on the politics of the Liberal government or the advantage this offers to the Conservatives. We need to look at the bigger issues that have been raised here, and that requires perhaps a Supreme Court reference or the appeal of this case with very specific parameters. Most Canadians, including most constitutional lawyers, do not believe that Indigenous communities are equally sovereign with the federal government on Crown land. This is a sovereign nation, and the federal government and its constitution are the articles, the instruments through which we impose laws. So we need to ask the Supreme Court, all right, how should we be interpreting that Constitution? Is there an absolute right of veto? What is the nature of that veto? How does it manifest itself? Can it ever be overridden? What does consent look like? Because unless we clear this up once and for all, one way or another, then yes, investors and Indigenous leaders and ordinary Canadians of all kinds are going to be left in this constant confusion. And we will be doing, and I cannot stress this enough, real damage to the economy of the country, to the lives of younger people who are trying to get a start and who are being frustrated in their efforts to get a start because of the obstacles we keep putting in the way.
And see, that only considers one side of the equation. What about literally the devastation done to Indigenous communities, their lands, their waters, the marine mammals that have been going on for decades, and the confusion caused in First Nations by the federal and provincial government's failure to abide by Section 35, forcing us to literally litigate hundreds of cases that keep saying the same thing over and over again: consultation, accommodation, and in certain cases, consent. And now that the federal government has committed to implementing the Universal Declaration on the Rights of Indigenous Peoples, don't forget that article says free, prior, and informed consent. And so it's very clear about where we're headed. The problem is industry's gotten a free ride all this time with all the breaches of Section 35. That's where the confusion lies. It's not in the nature of the right.
It's not about simply consent, though. Like I said, it sets up a situation of veto, and veto without any possibility of compensation or other means of obtaining the rights to build anything, whether it's exploiting this resource or others. Of course, there are other considerations here too, including the fact that marine waterways and potential damage to that. That's the other piece of the court's decision. They say that was not adequately taken into account as well. So environmental groups are also looking at this as a potential victory. But the difference is really, as you raised it, Pam, is the issue of title and sovereignty, as John alluded. It comes down to a question of sovereignty of government. And if the Canadian government does not have sovereignty on the territory of Canada, then the investors will look at that and say there's too much uncertainty here. If there is no possibility of compensation if consent is not obtained to continue with projects like this, then there are a lot of things which will not get built, a lot of things which will not get done, which will also hurt Indigenous communities who also are looking to the jobs that this kind of activity would generate in this particular project and others.
Pamela,
that presumes that every project is going to go ahead. And that would really challenge the credibility of the National Energy Board and any review process. If the assumption is all projects are going to go ahead, then that's a problem. What First Nations are saying, some can go ahead and some can't, when the potential for non-compensable damages are there, like destroying waterways, destroying underground water, killing all of the killer whales. That's not compensable in money.
But that is a fear and not established. And that is the point, is that there are every project has risks. Every project has risks, and we know that. Those risks are infinite if you want to look at them from a possible perspective, but they will not all materialize. They may not materialize at all. This pipeline has already been there.
They're guaranteed.
This pipeline has been there since the 1950s. It has not produced the kind of devastation. This is a twinning of that pipeline. It is not building a new pipeline. It is not it is a larger vessel to carry
I think even beyond the issue of the pipeline, we need to go back to ask ourselves, is in fact Trans Mountain just a symptom? Or not to mention the failure of Northern Gateway, not to mention the failure of Energy East, all the major infrastructure projects that have all been brought down through one kind of opposition or another, much of it Indigenous. We need to get clear of this. We need a decision, perhaps by the Supreme Court, on explicitly what the rules are, what order of government Indigenous governments are. Are they actually co-equal with the federal government? Does Section 35 give them that level of sovereignty inside the nation of Canada? And if it does not, then what are the limits on the rights of Indigenous Canadians to make claims on land that they claim or that is Crown land? We need to get clear of this once and for all. And I'm hoping that maybe Trans Mountain, through a Supreme Court reference, is the way that does it. But we need to get it solved.
Pam, I want to ask you, because and Tasha made this point, there are a number of First Nations along that pipeline which has existed for many, many years, who really supported this project, who are as equally disappointed in the fact that it's not going to move ahead as they are in Alberta, where there are going to be jobs lost. So, I take the point that you're making, but how do you make it right to all of those other people, First Nations people included in this, who do want to see this pipeline happen? And it does already, to some extent, exist in the area where they are looking to twin it.
That's an excellent question, because a large number of those First Nations who purportedly consented made very public statements saying, please do not misconstrue our agreeing to this project as consent. We're doing this under duress. We're being told it's happening anyway. We're going to drown in litigation. We don't have the money to fight this. We have no choice. And so that's not consent. That's not anywhere within the realm of promoting this. There might be a handful, and in their territory, if they're okay with that, that's one thing. But we're talking about the kind of risk that impacts multiple territories. So you don't just get to ask one. A pipeline goes over multiple. Increased tanker traffic impacts multiple First Nations. So we're in a situation where we have to look at all the risks, and you don't get to go to the token Indian and say, okay, as long as you agree, it's good for everybody. That doesn't work in this country, because we have many sovereign nations in this country, First Nations being some of them.
Okay, on that basis, though, a national project cannot go ahead, and that is the big issue here. Is that there are projects which impact more localized communities. Those, if you decide those on a consent-based basis, will not have the same impact that this project will, because here it's essentially, from what you're saying, impossible to obtain consent because you have so many actors at the table.
It's not impossible. They didn't do their job. They didn't mitigate the risks that were put before them.
That the Squamish First Nation would ever say yes?
To find out if they could get consent, and that's on them.
Honestly, Pam, can you honestly say any of these nations would absolutely consent? There's any price that could be paid that they would agree to, or any guarantee? I really doubt that all of these First Nations who are involved would give the consent you're talking about. Based on their statements, they are happy that this is not going to happen.
Not every project should go ahead.
Okay, I have to stop because I want the final.
Every project should go ahead. Some should, some shouldn't, and this one may well be one that shouldn't.
John, I just want to give the final word to you quickly. Your thoughts when we look back to when this was given the approval by the Liberal government, was this foreseeable?
Well, obviously they didn't foresee it. If they had thought that there was a clear and present danger that Trans Mountain would be struck down at the federal appellate level, surely they would not have put $4.5 billion of your money and mine into acquiring the darn thing, because we own it now and it's not good for much. So they must have not known this was going to happen. But that, if we do want to circle back to the political issue, that's why this is so bad for the Liberals, not just because of the huge risk that they took on Trans Mountain and now appear to have completely failed at that risk, but it goes to the question of competence on this issue, on climate change issues, on border issues, on trade issues. Is the Liberal government able to fulfill any of the commitments it makes? Right now, well, as I said, it's not a very good week for them.
Not a good week, and as you say, we still have those NAFTA negotiations that are impending, and we're waiting for any kind of word on that. Listen, passions on both sides of this issue, and I really appreciate all of you coming on air tonight and expressing them so articulately. Pam Palmater, Tasha Kheiriddin, and John Ibbitson, thank you very much.
Thank you.
Thank you.